So, are we all ready for a busy few months? Have we all cancelled the holidays we had scheduled over the summer to try and get to grips with all the promises that have been made by the Labour Party about new employment law that they'll introduce? A couple of admin points first. This will only be 30 minutes. Feel free to post questions using the Q&A function. We may not have time to get around to the questions, but if we don't within the webinar, then I'll endeavour to respond to them separately afterwards. But I have promised a 30-minute webinar, and as a good politician, I am going to deliver to that promise. Speaking of promises, next slide, please, Tom. So, are there problems with people hearing me? Tom, can you hear me?
Yep, I can hear you okay.
Yep. Okay. Well, I'll carry on. If there is other people with problems hearing me, let me know. We've just had one person report some problems, but if Tom can hear me, hopefully the rest of you can. This is the promise that has been made. Too much time has been lost already, so we will hit the ground running and introduce legislation within 100 days of entering government. So that's the first promise, to introduce legislation within 100 days. Now, that doesn't necessarily mean to change the law within 100 days. Legislation may be introduced with future dates for implementation. What they have also said before introducing that legislation, that the government will consult fully with businesses, workers, and civil society on all of those items of legislation. So a hell of a lot to do within 100 days. And I suspect that somewhere within Downing Street, Tom, if you could go to the next slide, please. Somewhere within Downing Street, someone will have a whiteboard with what you'd call a prioritization matrix like this set up. They will be looking at the promises they've made. They will be scaling the promises from, well, what were the clear promises we made, and on what promises do we have some room for maneuver on the one hand, and what were the easy things we have to deliver, and what's the more complex things we have to deliver. It will be fascinating to see what actually does happen within that 100 days. What I wanted to cover off today was a summary of what was covered in the Labour's plan to make work pay document, to talk about what the headline is, what the but might be about that headline, what the exceptions might be, or why it might not happen quite in the way the headline suggests, and what people ought to be doing now about it or in the near future. I'm conscious that we've got a lot of HR professionals on here who are being asked to report to senior management on the board saying, what do we need to be doing now? So that's what we're going to try and cover. Next slide, please, Tom. So first series of issues to cover come within what Labour have branded as securonomics. And what they mean by that is trying to give certainty to employees, to a certain extent to businesses as well, but primarily certainty and security to employees and workers. And the first one of those, and one of the big headlines, has been giving protection against unfair dismissal from day one of employment. That's the headline. The but is that the documentation suggests that employers will still be able to have probationary periods, but they will need a structured process to assessing performance during the probationary period. Now, we don't have any more detail on what that might look like. It strikes me that there's a couple of ways they could approach that probationary period exception. One is they could say, well, there'll be a slightly lower standard of fairness during a probationary period. Or the other is they might say, well, there'll be a different type of remedy available if someone is dismissed and claims they were unfairly dismissed during a probationary period, as opposed to at any other time. Qualifying period for unfair dismissal has gone up and down over the years. It was 1 year under the last Labour government until 2010. Then in 2012, under the coalition government, it went up to 2 years. The intention behind that was it was post global financial crisis. They wanted to encourage employers to recruit people and take a chance on people. So they broadened that qualifying period to make it 2 years at that time, to say, well, look, that gives you a fair amount of time to make decisions about these individuals. Now the agenda is very much going to be towards employees having protection against unfair dismissal from day one. We don't know exactly when this will be implemented. When the 1 year qualifying period changed to 2 years in 2012, it wasn't a retrospective change. So they said that it only applies to people who start employment after the 6th of April 2012, as it was. So it may very well be the case that here, the fair thing to do would be to say day one unfair dismissal rights will apply to people employed after, let's say, 1st of October 2024. Those who have less than 2 years service at the moment but have already been employed would still perhaps have to acquire 2 years protection. But we'll have to wait and see what happens on that. In terms of the impact it might have, and what people ought to be thinking about now, is impact on recruitment practices. Will this have the unintended consequence of employers being more wary about recruitment because they know that they need to make the right decisions at recruitment, and taking a chance on someone could mean that they then have to go through quite a drawn out dismissal process? Certainly a potential change in the culture of performance management in relation to new starters. And that's something that businesses will have to look at in some detail. So that, I think, is going to have, and some people have been saying this is one of the areas that will likely have the biggest impact on the employment landscape. The second issue that they cover off in this idea of securonomics is, again, the headline was, and for a few years Labour have been saying that they would ban 0 hours contracts. 0 hours contracts are a bad thing. They will ban them. What the promise now says is that they will ban exploitative 0 hours contracts, and there's a slight nuance there. So I think there's a recognition that there will still be, to a certain extent, the ability to have a casual workforce. But the important promise they have made is they have said there will be a right for workers to have a contract that reflects their regular hours worked over calculated over a 12-week reference period. So if someone is working regular hours, that might be someone who's on a 0 hours contract but happens to work every Tuesday and Friday, for example, will be able to get a contract saying you will work 4 hours every Tuesday and 4 hours every Friday. What it might also impact is employees who are on what we'd see as fairly standard employment contracts, but perhaps have regular overtime. So they always tend to work 4 hours overtime every week. It's possible that those employees might say, well, my contract is now 39 hours plus 4 hours overtime. Those are my contractual terms. Again, we don't have the detail, but those are two areas that businesses need to think about in terms of their recruitment strategy and their employment model. A ban on what they call exploitative 0 hours contracts could have a significant impact on a number of businesses that operate on a casual 0 hours model at the moment. The second thing that the third thing they talked about banning was fire and rehire practices. So this was where employers seeking to implement changes to terms and conditions where they can't reach agreement with the employees, terminating existing contracts of employment and offer re-engagement on new terms. And this received a lot of publicity around the time P&O did it a couple of years ago. The government, the Conservative government, said they would implement a code of practice on fire and rehire practices. What the Labour government are saying they will introduce is effective remedies against abuse, which they say there aren't at the moment. So again, the impression is employers in some circumstances may still be able to implement changes to terms and conditions by termination and re-engagement, but it will be more tightly policed. There might be bigger remedies involved. We don't have the detail. All we have at the moment is that sentence: we will provide effective remedies against abuse. The final issue, under this concept of secure economics is moving away from our current three-tier worker status framework. So at the moment, someone can either be self-employed, or they can be a worker, or they can be an employee. And workers have slightly different rights to employees. What they have said is they will move towards and consult in detail about, within year one, moving to a simpler two-part framework for employment status. So simply having you're either a worker or you're self-employed. And all of the workers will have exactly the same rights, and self-employed people have exactly the same rights. Now, this could be a significant change, again, to some models of businesses, particularly within the hospitality sector, where there is a casual workforce that are seen as workers rather than employees, and therefore not protected against things like unfair dismissal, not getting the same level of benefits as other employees. If we do have a system where we simply have a two-tier framework, then that could have a significant impact on those models. One of the other reasons mentioned in the paper why they've suggested this is they say, well, at the moment we've got lots of complicated case law around who a worker is and the worker test, who an employee is and the employment test. There's loads of grey areas there. It's very difficult to judge whether someone is where they lie in that border between a worker and an employee. So they've suggested they hope to get to a clearer framework, a clearer split, which in theory will mean less work for employment lawyers. We will wait and see. But that's something that's not going to happen in the next 100 days, I don't think. Could you pop to the next slide, please? Okay. Family-friendly rights. A few things to mention here. First is what they talk about is moving towards flexible working as the default. And what they mean by that is the current system is permanent working is the default. You can apply for flexible working. Your employer can reject your request, and provided they fit it within one of the statutory grounds for rejection, and provided they're not discriminating, the employer can do that. Again, we don't have details of the mechanics, but what the government say they will introduce is a system where flexible working will be the default. So the assumption will be a job can be done flexibly. The but there is they say except where it is not reasonably feasible. So there is a recognition that certain jobs it won't be possible to do flexibly. But there will be this added burden, I suspect, on employers. We've already seen an increase in the number of flexible working requests people can make. I think what we're seeing is the band shift even further to say to employers, you really have to convince us why this job can't be done flexibly. One specific thing mentioned in the manifesto was that of term time working and enabling term time working when possible. In relation to pregnancy and maternity, the promise is to make it unlawful to dismiss someone because they are pregnant or up to 18 months after they have given birth, except in specific circumstances. That's the but there. And again, we don't have detail on what those specific circumstances would be, but you could imagine gross misconduct would be one of them. There is a recognition that women who are pregnant and women on maternity leave and women returning from maternity leave, or people returning from any family leave, are vulnerable to being treated unfairly and vulnerable to dismissal. So this seeks to redress that balance. One of the areas that it will make important, and this is something we've been advising employers on since April, and the extension of protection against redundancy in these situations, is that of record keeping. Employers tend to have good records, and they tend to know who's on maternity leave or who's on family leave, but we will need records to trigger who has notified us they are pregnant and therefore protected in these scenarios, and who has returned from maternity or family leave and will therefore be protected up to 18 months from the birth. Something else covered by the family-friendly proposals is they say they will consider introducing paid carers leave, but the government is mindful of impact on small employers. So this isn't a bolted on promise to introduce paid carers leave. We had in April this year the introduction of unpaid carers leave. We have this possibility, this dangled carrot of paid carers leave. In terms of what employers can be doing at the moment, I know there are some employers who are looking at implementing paid carers leave anyway. They feel that it is the right thing to do. They feel that it helps them recruit talent and retain talent because of the increased number of people who do have caring responsibilities. So that might be something that the HR professionals and managers might want to be thinking about at the moment. The final issue on family-friendly rights that I want to mention, and it's not my decision to put this under the family-friendly slide, it's the government's decision. This came in the family-friendly section of their policy document, is the right to switch off. Now, why that should be related to families, I don't know. I think that people without families should equally, if there is a right to switch off, have the right to switch off. And by right to switch off, they mean the right not to have to do work outside of core hours, not to have to answer emails late at night or on holiday. They talk about moving to a system similar to the Belgian or the Irish model, who have introduced legislation along those lines. What those models have is a system that says, well, we recognize that one size can't fit all. There are different industries, different employers, different practices. So what it requires employers to do is to have constructive discussions with staff about what works for that employer and that area. So not necessarily a one-size-fits-all solution, but certainly a recognition of the fact that there ought to be an element of the right to switch off, that it ought to be regulated. But to a certain extent, I expect legislation here to be one of self-regulation rather than a diktat saying no employee in the UK shall be required to answer an email after 5 p.m. Next slide, please, Tom. Fair pay. So there's a number of proposed reforms in relation to pay. First relates to national minimum wage and both the level at which that might be set, but also, interestingly, the removal of age bands. So at the moment, the national minimum wage you get is dependent on your age, and they say they will remove those age bands. Interestingly, not everyone is in favour of that. My 15-year-old daughter was looking forward to trying to get a job as a 16-year-old like her older sister did and get lots of hours because restaurants prefer paying 16-year-olds a lower wage than they would do to a 25-year-old. So there's lots of work out there for 16 to 18-year-olds who want to get it. So my 15-year-old daughter is not very impressed by this proposal. What they talk about, as well as removing the age bands and looking at the level of national minimum wage, is greater enforcement of national minimum wage, particularly within the context of home care and travel time. And there are laws around that. The laws can be a bit complex. They consider that there is still underpayment of people who are providing care in people's homes, and that they will seek to address this through their single enforcement body, which I'll return to later. So employers now certainly ought to be cost modelling on the basis of the removal of those age bands. This is something that could happen relatively quickly. I know national minimum wage changes in April each year. Whether they stick to that, I don't know, but it's something that could happen relatively quickly. It's a fairly clear promise that has been made, and there will need to be some cost modelling involved in dealing with that. There's a very clear promise with no buts about entitling people to statutory sick pay from day one of absence, as opposed to having 3 waiting days. So employers perhaps need to do some modelling around costing of that. Again, no implementation date, but something that is relatively swift and easy to implement. Queries about the consequences of that might be, will that mean there is less presenteeism, people turning up to work because they can't afford to take a day off? The cynic might suggest, will it result in more hangover related absence? Because at the moment, if you've got a 1-day hangover and you're only entitled to statutory sick pay, you don't get any sick pay for your 1-day hangover. Now you'd get statutory sick pay for your hangover. That's a cynical approach. I accept that, but I know there are some businesses that are thinking that way. Some of the businesses that offer company sick pay are thinking about their waiting days for company sick pay, whether they have them at the moment, whether they might want to introduce them, because companies are entitled to do that over and above statutory sick pay. They would be entitled to do that. Another issue on fair pay, fair allocation of tips. We have legislation due to come into force in October. It was due to come into force in July, due to come into force in October on this anyway, requiring employers to consult with staff and implement a policy on the fair allocation of tips. The very vague promise in the manifesto and documentation, the government just simply saying they will make sure there is fair allocation of tips and tips go to workers. They might live with the current legislation. They might go a bit beyond it because the current legislation doesn't tell employers explicitly how they have to allocate tips fairly. It just says they need to have a system for fair allocation of tips. It's possible this government may go slightly beyond that. Those in the hospitality industry in particular need to keep an eye on that. Finally, on fair pay, there is a big issue around pay in the social care sector. Very high vacancy rate, very high turnover rate, recognise that people are leaving important social care jobs to take better paid jobs in other sectors. This is a big, and with the increasing need for social care, this is a big issue for the new government. They say they will consult widely with employers, employees, trade unions on the design of a fair pay agreement within this sector. Those operating within that sector will want to be doing some cost modelling around this, may want to be participating in that consultation. I think this will be a significant area for movement over the next year or so. Next slide, please, Tom. A few issues to mention on equality. And these mainly relate to large employers. So employers who currently defined as a large employer as those with 250 or more employees. We have mandatory gender pay gap reporting at the moment. The government say they will implement mandatory ethnicity and disability pay gap reporting. We don't have the timescale on that. It's the sort of thing where you would anticipate there will be a decent lead in time because you'll have to report on the data from a specific year. So the government can't simply turn around to you in October this year and say, right, well, you need to report on your ethnicity pay gap for the year just gone, because you won't necessarily have gathered that data. So I anticipate there'll be a bit of a lag in the introduction of that, but businesses ought to be planning now for that to be implemented. Many businesses do it already voluntarily, but you want to be planning for that in the same way and operate it in the same way as you do gender pay gap reporting at the moment. Large employers will also be required to produce a menopause action plan to explain how they are and how they propose to address issues affecting women experiencing menopause symptoms in the workplace. The final thing to mention on equality, it's been in there in the Equality Act since 2010, but was never implemented after we had a change of government, is the obligation on public bodies when they are making policy decisions to take into account the impact of socioeconomic diversity and people from disadvantaged socioeconomic backgrounds. So they will have to factor that in to their equality impact assessments. Next slide, please. As you would expect from a Labour government, there is a fair amount in there about collective rights and the involvement of trade unions in the workplace. The most important element, I think, is the impact on collective redundancy consultation. At the moment, The trigger number is 20 or more redundancies at one establishment. And so a business that has lots of different outlets across the country, lots of different factories or shops or whatever, there is case law about what constitutes an establishment. And generally speaking, if you've got a factory in Newcastle, factory in Cardiff and a factory in Kent, and they are distinct entities, it will only be triggered if you are proposing 20 or more redundancies at one of those specific factories. The government have said they will change that and the thresholds will apply across the business as a whole rather than individual establishments. So that will require some record keeping and some thought. They've not set what the thresholds will be. Don't anticipate they'll increase them, but that I think will be an important change. They've said they will do things that help out unions in terms of repealing the recent legislation about minimum service levels, allowing electronic balloting because it all has to be postal ballots at the moment, simplify the process of union recognition, better rights for unions to access workplaces, put a duty on employers to inform employees of their right to join unions, and to reform blacklisting law in relation to union activity. So there's a fair amount of stuff there for those of you who are operating unionised environments, as you would expect, to try and strengthen union position. Next slide, please, Tom. Okay. All very well having all these new laws, all these new rights. Rights without remedies are meaningless. You need to be able to enforce them. So the government have said they will be serious about enforcing employment rights. And there are three things that they mentioned they will introduce. One is a single enforcement body. So at the moment, we have the EHRC enforcing equality rights. We have HMRC enforcing national minimum wage, etc. They will have a single enforcement body whose job it is to enforce employment rights. They've not come up with a name for this yet. I've been thinking of a few names. The labour force, the employment avengers, or my favourite, the Strategic Task Force for Advancing Rights and Monitoring Employment Regulations. And if you've written that down, you'll recognise that that spells Starmer. So I think that would be a good name for their single enforcement body. They're going to extend time limits for bringing employment tribunal claims. At the moment, you have generally, for most claims, 3 months to bring a claim. The proposal is to extend that to 6 months. Certainly for discrimination claims, possibly for all claims. And the final thing they say they will do is better enable collective grievances. So individuals who are experiencing problems at work don't feel vulnerable, don't feel reluctant to raise individual grievances, that they will better enable a process of collective grievances to be raised. And when they do that, employers will need to come up with a collective grievance policy and an efficient way of dealing with those. Next slide, please, Tom. Final slide, something that isn't mentioned a lot in the government's proposals. There is a vague reference to the fact that they will consult with employers about the impact of AI. The reason why I mention this is the thing that I think is missing. If we are asking, where will we be in 5 years' time in terms of employment law and the labour market? Some of these changes that I've mentioned may well have an impact on the labour market and the way people are managed and the number of jobs we have. But there does need to be, in my view, a very wide conversation around the impact of AI on the way in which employment law works, so the use of AI in recruitment, for example, but perhaps more importantly, the impact AI will have on people's jobs. And what should we now be training people to do? What jobs do we think will be around in 5, 10, 15, 20 years' time that aren't around at the moment? And what jobs will disappear? There have been studies done recently about the potential impact, particularly on women in the workplace, from AI and jobs that have historically been done by women and the potential discriminatory impact of AI. So if I were the government, I would have been I think this needs to be high on their agenda as well. I'm 1 minute over on delivering on my promise to finish within half an hour. So we don't have time for any live questions, but I will have a look at those that have appeared in the Q&A function and respond to them later. Thank you very much, everyone.